So this morning, we would like to discuss postmodernism and legal theory, or postmodernism and the law. This postmodernism is a very important dimension of intellectual inquiry, which cannot be disregarded in any serious study, including the study of philosophy or jurisprudence. So we'd like to spend some few moments to discuss that. Yeah, so in this particular discussion, which is a very brief one, we would like to explore the key themes and the proponents of thinkers in postmodern philosophy. Particularly, we would like to explore their ideas regarding uh, how law can be evaluated or critiqued, particularly from the point of view of certainty, objectivity, and then authority. And what are the implications of postmodern thinking for courts, legislation, and legal interpretation? And of course, as we have already noted, no uh, legal theory or no philosophy of law is flawless. So you definitely have some downsides, some shortcomings. So we will be exploring that. So that's what we seek to discuss. So postmodernism, you might have heard it about. And what is it? Well, it is that diverse intellectual movement which seeks to challenge universal truths and stable narratives. In other words, for a postmodern thinker or for postmodernists, we shouldn't take any knowledge as settled. We should be cautious. We should be skeptical about so-called settled knowledge or universal consensus or truth, as it were. And for that matter, postmodernism emphasizes fragmentation, plurality, and contingency in knowledge and culture. What do postmodernists mean by fragmentation? Fragmentation, as we know, like the fact that things are not one whole. The thing is not, one whole, is not united. It's, splits into compartments or segments. So that's a fragmentation. So for them, we don't have monolithic, or we don't have an overarching, uh, knowledge with respect to objectivity or truth or certainty. Rather, they see everything as being relative, as being contextual. In other words, it depends upon how you are looking at it. It depends upon the perspective or the angle from which you are viewing it. And that being the case, we are going to have multiple, or what we call the plural versions of everything. Because of the idea of fragmentation, definitely we are not going to have just one thing. We're going to have a series of perspectives, as it were. And so that is the plurality we are talking about. And then the contingency. The contingency, that is, it depends, So postmoderns are actually who sponsor the idea, it depends. That whatever you are talking about, it depends upon how you are looking at it. It depends upon the culture. It depends upon the time. It depends upon the society, and so on. So that is the focus of postmodernism, that yes, we shouldn't take anything as given. We shouldn't take anything as its face value. We must be skeptical. We must deconstruct. And for that matter, we realize that objectivity, which is often presented or served to us by a lot of proponents of ideas, will be seen as illusory, or be seen as an exercise in an illusion, something which is really not just there, as it were. So let's keep that in mind. And for us, it is important that we may not agree with all that postmodernists are saying, but there's some intellectual attraction in some of their arguments, particularly the aspects which gravitate towards critical thinking. And of course, students of a Presbyterian University, I know it's compulsory for you to do critical thinking and logic, so you know what I'm talking about. So I'm just reminding you of something that you are supposed to know already. But I think that intellectual attitude of skepticism, of doubting universal wisdom or universal truths, and rather putting you on the path, on the trajectory of inquiry, of probing, and in itself has a certain value, which we as students of the law, I think that we will profit from. So what are the core principles, the core teachings of postmodernism? So to start with, postmodernism makes rejection of meta-narratives. In other words, postmodernism disputes any grand overarching theory, maybe such as absolute reason or historical inevitability, and rather prioritizes local contextual truths. In other words, postmodernism does not embrace the idea that you can have one master explanation, okay, for a whole lot of stuff, as it were. For example, some scholars will propound what they call historical inevitability. That is to say that, well, based upon certain antecedents, then there are certain happenings or certain things which will definitely happen due to certain antecedents that we have seen. Now, postmodernism rejects that. Postmodernism does not believe in having so for example, it will reject attempt to have like all the things that natural law or even legal positivists, trying to provide one explanatory framework for a whole lot of phenomena. Postmodernism is quite suspicious about that. So that is what we mean by saying that they reject meta narratives. Another core principle is social constructivism. That is to say that as far as postmodernism is concerned, knowledge, when we say knowledge, it also includes legal norms, knowledge of the law, or juridical norms. It's influenced by power relations and language rather than purely objective reasoning. In other words, for postmodernists, knowledge in any sphere, in any field, including even law, the knowledge of the law, is shaped by power relations and language. So that is what shapes knowledge, be it the area of law, be it any other field. So that is the point they are making. And it's not so much about maybe objective reasoning, like you try to reason some principles from certain premises using some kind of maybe logical syllogism and so on. No, that is not necessarily the case, but it's rather those who are powerful, those who control certain narratives and so on. They ultimately shape our knowledge of the law and knowledge of other things. So that is the social constructivism. Then the other core principle is plurality and relativism. Plurality and relativism. That is to say that postmodernism underscores the idea that we have multiple, not many, plural, right? We have multiple and even sometimes conflicting viewpoints on the same subject matter, the same phenomena. There may be more than 2 or 3 explanations, and some of these explanations may even be conflicted. As far as postmodernism is concerned, I mean, that is still tolerable because there's nothing like universal objective truth. That is what postmodernism is trying to say. Of course, talking about postmodernism, if we put on our religious, cap, like maybe as a Christian or as a Muslim or any other religion, you will begin to feel uncomfortable because postmodernism thinking, in a way, is also a challenge to religious ideas, because as we will notice, most of the prominent religions I have mentioned believe in universal truths. But this morning, thankfully, we are not running a course in theology or Christian ethics. So we are students of the law, philosophy of law, jurisprudence. So we just limit ourselves to that and leave the other things for other occasions, for other models. So therefore, to postmodernists, there's no single perspective or rule. And of course, it is, you might have heard of what we call relativism, right? Relativism, an idea which became popular so many years after the Second World War, in which people begin to reject single maybe like universal truths on anything, and would rather like to contextualize everything and say that whatever we have to deal with is so much dependent upon what you are talking about, where you are talking about it, when you are talking about it, and so on. So there's that plurality and relativism within postmodernism. Now, how relevant is postmodernism to law? Why should we be interested in postmodernism when we are exploring the nature, the essence of law? Well, law, as we know, is often grounded on ideals of objectivity and coherence. And you remember some of the earlier major theories, the natural law school, and even the various strands within legal positivism. Even if you come to legal positivism, you notice that they would like us to believe that there are certain objectivity and coherence, that is internal consistency. If you look at those scholars like Hart, John Austin, and all those scholars, in a way, they try to present a certain objective view of the law. Natural law scholars, of course, will talk about universal principles, right, of higher morality, which should actually shape or influence the law as it were. Now, to all those ideas, postmodernism sees them as constructed. In other words, postmodernism disagree that we have ideals of objectivity and coherence. And for that matter, postmodernism will highlight how textuality, that textuality has to do like the text, like the content, discourse, and power shape legal outcomes as much as rational doctrine or precedent. In other words, it's not just well crystallized doctrines of the law or precedents. They are not the only things which illuminate our understanding of what the legal position is. There are others, and those others are textuality, discourse, and power. So, what is the discourse built around a particular phenomenon as contained in any text? And also, who are the power brokers? Like, what is the power, the power relations in relation to that particular thing? And I give you, we have our constitution, for example. We have so many provisions out there, and I'm going to give you maybe like a typical example, like the ongoing the Article 146 and so on. How people reciting, precedents, right? Precedents are cited, but postmodernists will tell you that we shouldn't understand the law only from rational doctrine or precedent, but it's also about textuality, it's about discourse, it's about power. So, what is the discourse? For example, it may well be that there has been a certain maybe social commentary on certain matters. And all those commentaries impact upon how ultimately certain positions of the law, for example, are understood and are interpreted. So that is the point that the postmodernists are trying to tell us. And that is why one scholar, Lyotard, will make the point that he would like to simplify to the extreme and define postmodern, that is, as incredulity toward meta-narratives. The incredulity means that complete lack of faith or persuasion. They are quite skeptical about meta-narratives. Meta-narratives is just an attempt to have a single overarching explanatory framework for anything. They reject that. And we have explained what it is. And that is why some of the theories of the law will actually crumble. Because if you look at Kelsey's theory of pure law, he will try to build one grand explanation of the validity of the law, bindingness of the law, efficacy of the law. Is a ground known theory and all that. It's just an attempt to have one single explanation for the legal system, as it were. And that is example of meta-narrative. And legal and postmodernism will reject any such thing. Now let's explore briefly the historical and philosophical roots of postmodernism. So this approach to knowledge, epistemology, how did it come about? Well, structuralism definitely influenced what we call postmodernism. So we have early structuralists like Ferdinand de Saussure, who analyze underlying systems in human culture. So like if you take human culture, you want to understand it well, he decided to use language that, of course, this especially, he is also like is a linguistics. Those who study language, that if you study the structure of language regarding any particular matter, it will also help you to properly understand the thing that you are interested in. So that's like the structure, how knowledge is organized, the syntax, the grammatical configurations, the various levels of meanings which are conveyed in that particular language. Then we also have later scholars, what they call the post-structuralists, who built on this idea, but argue that these structures are never stable and are open to contingency and change. So they too will say that yes, if we take even the structure one may discern within a particular language, as it were, because don't forget that language is the vehicle of what? Ideas. It is language which enable us to convey ideas. So if you let's take the view that the structure And then the grammatical patterns or configuration of a language will tell us a lot. And that is all that we are using. Later scholars will say that, but there could be a problem, because if you look at language, if you look at the structure of language, you notice that it's not static. It also evolves. It undergoes some transformations or metamorphosis depending upon what is happening. And if we are to cast our minds back, if you take even like the English language, those of you who are students of Shakespeare, if we take Shakespearean works, there's what they call the Elizabethan language, pictorial language, and all that. You will know, if you take like the Bible, in James' Bible, sometimes say thou, thou, thou. No, you mix those things over there. So one will regularly notice that there has even been some changes in how grammar of the English language is. And that is what the post-structuralists were actually reminding the early structuralists of. Then we also have a deconstruction. So the philosopher, I'm sure you've heard of him, Jacques Derrida. For him, he takes the view that any text, including legal text, like be it an act or statute or whatever, contains contradictions and unstable meanings. That in any text, you see contradictions and unstable meanings. And of course, later on, when you are learning the law of interpretation, it's probably because of the awareness of this observation by Jacques Derrida, that if you take any text, you will notice that that text contains contradiction or unstable meaning. That probably explains why a presumption of interpretation will arise that the law is presumed to be coherent. In other words, the lawmaker is presumed to avoid contradictions and rather seeking to achieve coherence. Now, if that is the case, then in your effort to unpack the meaning of the law, you try to always achieve interpretation which is coherent, which avoids contradiction or which minimizes contradiction. So you don't read any legislation and say that here is contradicting there. No. Assuming you even saw it that way, you are supposed to read the text of the law in a way which will achieve coherence, in a way which will avoid contradiction. Yeah, and of course, this deconstruction approach of the writer certainly will undermine the notion of a single correct interpretation of status or precedent. And as I've said, it's probably because scholars of interpretation are aware, and that is why we have a presumption of consistency, that the lawmaker is presumed to be coherent and consistent. And for that matter, when you are reading any piece of legislation, you try to read it in a way which will not allow the contradiction to be manifest. Again, disillusionment with modernity contributed towards the emergence of postmodernism. So in the 20th century, a couple of monumental events, such as the World Wars, and the World Wars are very important. And of course, we pray that we don't get any World War again, or for now, because let's talk about World War, especially the Second World War, and the the scale of human lives which are lost are just unimaginable. And if you look at the current, weapons which nations have in their arsenals, the kind of, destruction they can cause cannot be imagined. It can turn more or less a whole planet into inferno. And that is why the world wars are actually a very terrible thing. So, the world wars we have experienced led to skepticism about Enlightenment ideals of progress and rational certainty. Because don't forget, if you take the period of Enlightenment, for example, the 18th, 19th century, a lot of progress had been made with respect to science, the use of the mind, rationalism, and all that. For the same human beings that have actually presided over this beautiful development will end up slaughtering themselves like mindless, senseless beings. Then it makes everyone begin to doubt whether there is any wisdom in all these things. So that's the point we are trying to make. So postmodernism emerged as a broad critique of foundational assumptions, which include the premise that law is purely rational and objective. So postmodernism is, as I said, deconstructionist. It's critical of underlying assumptions. And in no time, you'll be hearing the intellectual movement called the feminist jurisprudence or feminism. And some will say that, yes, if you look at how the law and the legal system is, it is largely constructed by the patriarchy, male-dominated worldview, chauvinism, and the other gender, female, its perspective, its way of viewing things, understanding things, experiencing things, have not very much been taken care of as far as the law and the knowledge of the law is concerned. And that thinking, we'll notice, is not only about law, it's also even about sexuality. And that probably explains why in the post-Second World War, there was the so-called sexual revolution. That is to say that if we look at how society even understood sex. It was understood from the male perspective. And the female orgasm, for example, was not something that was really taken into account. But after the Second World War, if we look at it, that the female gender also begins to bring their own perspectives of how to experience things into the narrative. So where I am, they've just taken the light. I hope you have light, but once we are recording, if you don't have light, you can later play it back. One key postmodernist scholar is Michel Foucault. Michel Foucault, a very respected scholar whose teaching attracted people to travel from all over the world to go and listen to him. So Michel Foucault investigated relationship between knowledge, power, and social institutions. So he will take, for example, maybe either the field of medicine, like the clinic. For example, he wrote the archaeology of the clinic. If we take like the hospitals or how medical care or healthcare is, for example, approach. And he will say that there are important power relationship at play. So he studied how discursive regimes define what is normal and shape self-perception and social structures. So trying to say that most of the things that we know, we are familiar with, are actually shaped by those who control the narratives. Those who control the narratives, they shape it. And of course, this narrative thing you're talking about is so powerful. And I think it has to do problems with propaganda as well. And that is why in our times, for example, when it comes to either social or political space, you notice that various groups would like to take control of the narrative. When it comes to even war, like the war going on in the Russia, Ukraine, Israel, and the rest, apart from the direct physical violence, which they are in relation against each other, each side is also desperate to present the narration, the story of how things are unfolding, so that they're able to present it from their perspective. And the same thing applies to when it comes to world news, right? Global news now, international politics. If you look at major news cables like CNN, BBC, Al Jazeera, Russian television or RT, then the Central China televisions and so on, BBC. If you look at these networks, you notice that they try to present world news, happenings in the international arena from their preferred perspective. And they use that to control the narrative. And so if you have the time to actually compare how these networks present news, it will confirm this observation that we are making. So controlling the narrative is very important. And that is why the postmodernists will say that those are the things which actually shape what we know and what exists, not because of any objectively reasoned or derived inference. But Michel Foucault made certain contributions which are also relevant to law. For example, when it comes to discipline and punishment. So he will teach us that legal systems are part of disciplinary societies. So using punishment, surveillance, and classifications regulate behavior. So that is how law comes in. Of course, we have been told previously by some of the sociological philosophers that law is actually an instrument for social engineering, as it were, that you can use it to get people to behave or change their behavior or their ways of doing things in a particular way. So that way, you are agreeing with the observations by postmodernists, including Michel Foucault, that law then is not that objectively neutral. Law is a construct. Law is a social construction. Again, he makes the point that law does not only punish, but also works to create docile bodies that internalize control. That is to say that the way the law works, you are born, you are introduced to certain existing legal arrangements, and you keep adding to them. So you certainly imbibe the things which are taught or prescribed by the law, so much so that you obey without even questioning, right? You obey without questioning why you should obey it. So that is the the docile bodies that Foucault is talking about. Docile bodies which have internalized the control. So, for example, all of us, we stop at the red light, traffic light. It's something we obey. We don't question it. And not only that, you're supposed to file your taxes. You file your taxes without questioning why somebody should ask you to pay a certain tax and so on. Because over time, our bodies have sort of become malleable and have become docile, so much so that we have internalized this control by the law. Again, Michel Foucault makes the point that power not only coerces, but also produces categories and norms. So, yes, power coerces, but beyond the power of coercion, it also creates categories and norms. So, for example, and that is important because it really influences how we classify and treat individuals. Let me give you a typical example. When it comes to mental health, okay, mental health will surprise you. It's not just a question of scientific conclusion or scientific observation. Mental health is rather a legal conclusion. It's rather a legal observation. How is it so? How is it a legal observation? Because if you look at the law, it is a court of competent jurisdiction, or a quasi-judicial body of competent jurisdiction, which can make a determination as whether a person is insane or not insane. So that way you notice that it's not so much about just scientific objectivity only. And in any case, when it comes to even trial, right? Of course, you haven't done a lot of civil procedure and then criminal procedure, but when it comes to trial, there's something we call like expert witness or expert evidence. Now, expert evidence certainly is evidence provided by a person having technical expertise with respect to the matter at hand. So one will say that if the expert has said this is the position, shouldn't that be the final position? But the law will say no, that it is the judge, the adjudicator, the one doing the adjudication, who has the ultimate responsibility of making the requisite findings of facts, the conclusions, and so on. And that the expert evidence, the expert witness, is only supposed to assist the court, but it cannot take over the position or the approach of the court, as it were. So let us keep that in mind. And of course, even when it comes to majority and minority, okay, as whether someone is minor, whether someone is what do you call an adult, is also a question of the law. It's a law which will say that yes, you are a minor. And in the law of contract, for example, when you are learning about capacity, you have been told that at common law, the age of minority is what, 21 years? But now, with our Children's Act, it's 18 years. And you look at the recent Companies Act of 2019, to be a director or subscriber and so on, you have to be 18 years or more. So inferentially, then the positions assume that the age of minority now is what? It's 18 years. I mean, regardless of whether it's 18 or 20, but the fact that the age is pegged as a certain number in itself will tell you that it is a law which is actually determined whether someone is a minor as an infant or someone is a major as an adult. So, and that one is not any objective, if you like, reality. It is just a law. So that is the point, postmodernists like Michel Foucault is trying to tell us. So legal norms can mirror the worldview of dominant groups embedded in institutional power. So legal norms are presented to us, and we, as very uncritical, maybe minds or persons, may just take it at face value. However, Michel Foucault and other postmodernist thinkers is telling us that These legal norms are actually a reflection of the worldview of dominant groups. So we see a bit of if you like, a coincidence with the Marxist thinking, where they will use the base and the superstructure. So he was interested in using what we call the genealogical approach or genealogy, by which you use the historical method to explore how legal or moral concepts evolve from particular power struggles rather than from neutral progress. So, in other words, if you want to understand the law, if you want to understand society, it is important to be interested in trying to understand historically, did we have any power struggle? Did we have struggle between certain groups of people or interests? And out of that struggle, what emanated from say, and that probably a certain negotiated position, a certain compromise was struck. And that explains why we have a certain position. So, Michel Foucault to say that the genealogy of all such are very important. We also have Jacques Derrida, which we have mentioned already. And he is known for deconstruction, which is a strategy for reading that reveals contradictions in text, and for that matter, seeks to undermine fixed meanings. So he did a very important work, what we call of grammatology. So in his work of grammatology, he said that, well, if you get any text, what you need to do is to read it with open eyes, and you will notice that there are a number of contradictions on the face of that text. And if you are able to spot the contradictions, then what it means is that you cannot really say that the text has a fixed meaning. Because if it has a fixed meaning, why will it be riddled with so many contradictions? So therefore, at the end of the day, the meaning to be superimposed on that text will be very much dependent upon who is reading it and for what is he reading it. Okay? So, law, for example, is supposed to be seen as a test. And if it is supposed to be seen as a test, then within his work of grammatology, you also look at legal rules and judgments expressed in language as being inherently unstable and open to contestation. Of course, if you take legislation, okay, if you take legislation, for example, sorry, yeah. If we take legislation, for example, you will notice that it is language which is used to craft or write legislation. And this language itself, as we know, has its own imperfections. If for nothing at all, we studied Wesley Newcomb Hoffel's analysis of rights, as in last week or last 2 weeks. And we've noticed how Hoffel made the observation that language behaves like the chameleon. You know the chameleon, that type of lizard or that animal, which changes its color according to the color of the environment in which it finds itself. So, language is very much like that. And if that is so, then it becomes difficult for us to avoid contradictions and contestations when it comes to the law. And again, when it comes to judgments that respect to precedents, they are also written using language. And sometimes a judge will write an opinion, and that opinion is said that you may not even understand like exactly what the court is trying to say, and you may need to even get the judgment also what interpreted or clarified. So all these observations reinforce the point that law is actually a text crafted using language, and for that matter, it suffers from the weaknesses of language, which make it actually amenable to contradictions, as it were. So let us keep that in mind. So we also have this problem of legal indeterminacy. And if language is never fully determinate, in other words, if language cannot be approached as with mathematical precision, and language is elastic, right? Language is so elastic or is so fluid. Then it follows that legislative or judicial tests can also yield multiple interpretations. And of course, the fact that our legal system recognizes interpretation, particularly so if you take, let's say, the Constitution, right? If you take the Constitution, for example, take Article 2. If anyone is of the view that anything has been done or has omitted to be done, and same contravenes the letter and the spirit of the Constitution, that person may invoke the original jurisdiction of the Supreme Court and seek the requisite declarations and so on. Now, the fact that the court may render interpretation is a confirmation that we have indeterminacy, we have lack of exactness or precision as far as the legal text or the law is concerned. After all, why interpretation? Isn't it because we have ambiguities? When what are ambiguities? Isn't it because a particular text is yielding more than one meaning? And for that matter, we need authoritative pronouncements as to which of the competing meanings should be the prevailing understanding of the law. And that is, of course, that is the point of interpretation. You go to court, particular text or particular law, or even like a contract, a clause in a contract, which is capable of yielding 2, 3, or more meanings. And then we don't know which of the meanings should be taken as the governing position, so that we are able to evaluate or judge people's conduct or omissions according to it. Then the court will have to come and render interpretation. And the interpretation is essentially to adopt one of the several competing meanings. And all these happen because of legal indeterminacy. So therefore, judges do not simply find meaning, they construct it. And that is what Jacques Derrida will teach us. That judges do not simply find meaning, they construct it. Because just look at it. If there are several competing meanings, are you just going to pick one? What enables you to pick one over the others? Isn't it because of a certain viewpoint, a certain worldview, a certain bias, or a certain perspective which you have? So Jacques Derrida will encourage scholars to see how legal discourse can privilege certain words, categories, or interests, and at the same time marginalize others. So that is a lot of food of thought for a lot of food for thought for us. We also have another postmodernist scholar called Jean-François Lyotard. So Jean-François Lyotard is associated with the end of the grand narratives. So he describes the postmodern condition as skepticism about grand theories and universal truths. And of course, as I said, that as a Catholic Christian, when I study some of the postmodernist claims, it makes you feel uncomfortable. But as I said, that when you're a student of the law, you immerse yourself in the law, and then when you are dealing with matters of theology and other things, you look at it from that angle. So we are just looking at the philosophy of the law now. So he is, quite skeptical about having, a meta, one big single overarching theory which seeks to explain things. And he rather emphasized local mini narratives over overarching systems. So instead of having meta narratives, you rather prefer mini narratives, small explanation for just a small context, as it were. And this has implications for law. For example, it challenges the idea that any one legal framework or concept of justice can be fully universal. So therefore, following Jean-François Lyotard, it will not be permissible for you to have legal theories or concepts which attempts to provide explanation of the existence of the law, the operation of the law in all societies. Now, Lyotard is quite skeptical about that because he says that that is not there. Rather, you can look at maybe a small area of the law within a particular society and try to provide explanation just for that, but not any overarching system which will hold good. Just like what people like Kelsen, Austin, and so on actually sought to do, or even John Finnis. So Lyotard argues for a more localized and context-driven approaches to legal decision-making. Of course, when it comes to law, for example, I'm going to give you one instance from our own jurisprudence. Now we have a legislation which we call like the Stamp Duty Act, okay, which among other things says that if you have any documents which is amenable to payment of stamp duty, like the tax or then if the stamp duty has not been paid, that document cannot be relied upon for purposes of evidence in any judicial or quasi-judicial forum, as it were. Now, before the current legislation was passed, the approach of the court was that if a document is being tendered, for example, in a land litigation, somebody is tendering a lease or power of attorney or anything, and it does not have the stamp duty previously, the judge could adopt it and say that it is provisional. You have to go and pay the requisite stamp duty, either the land's valuation board or whatever, before the court can use this document you have tendered fully. So that was all right. But there's a case, the Lazarus case, which we come across, came up. And then the Supreme Court to say that it is no longer correct position of the law. When the law says that you must have paid the stamp duty, when it becomes a condition for admissibility. And once the condition precedent for admissibility has not been met, then the document is not admissible. So therefore, if the judge cannot admit it, because the law says that there must be evidence on the face of it that the requisite stamp duty has been paid. So either it has been paid or it has not been paid. If it has not been paid, the condition for admissibility has not been met, and for that matter, it is not admissible. So as simple as that. Now, that point, simple though it appears, I must tell you, is creating a lot of problems for litigants, especially when it comes to land matters. And there are times that a whole decision regarding the declaration of title to a land has turned on this simple point that someone has not paid the requisite stamp duty. And sometimes the consequences are so unpleasant. And for that matter, last year, there was an invitation by some litigants to the Supreme Court that the Supreme Court should use its power to depart from precedent, to actually depart from this illusory line of jurisprudence, so that the hardships associated with strict adherence to this particular rule will be mitigated, but the Supreme Court disagreed. So instead of presuming a singular definition of justice, a postmodern perspective acknowledges that different communities have distinct values and norms, and that require flexible or pluralistic legal frameworks. Well, so if you go to those communities where galamsey is being done, okay, what is justice for them may not be so much arresting, prosecuting, and imprisoning the people doing the galamsey. But more importantly, repairing the environments which have been destroyed in those communities, restoring the vegetative cover, healing the polluted water bodies using whatever scientific methods which are available, and also creating alternative livelihood, that is other economic activity for the local people who were rather benefiting from the illegal, if you like, mining or say, to do. So from this simple example, you begin to see that there is some truth in the observation of, let's say, Jean-François Lyotard and other postmodernists, that you cannot have a single definition of justice, and then justice may actually be contextual, just like the example that I use. So for them, those communities where the say, for example, is being done, if people are arrested and they are found guilty and in prison, it's good, but for them, that is not the real justice for them. The real justice for them is for the environment, which have been destroyed, to be repaired, for them to get an alternative, a livelihood. Yeah. So, having said all this, let's try and bring the scattered explanations of the law, which we have been encountering in the individual postmodern scholars. So, therefore, we can say that the postmodern critiques of law really comes with this: one, indeterminacy; two, power and hegemony; decentering the subject; and then four, subversion of hierarchy. So let's explain each of these. Indeterminacy. What criticism is that? That is to say that according to postmodernists, legal texts do not yield one true meaning. They are subject to ongoing what? Interpretation. And of course, we may agree with them because we have seen, even if you read Hart's concept of law, I think the first two chapters, it was about the indeterminacy of language, isn't it? Now, if you look at the Hoffel that we encountered, he also talks about the elasticity of language. Language behaving like the chameleon, so there may be some truth in that. And regarding the indeterminacy criticism of the law again is that even precedent is malleable, as judges reinterpret past rulings from new vantage points. Of course, when it comes to precedents is also not free from this accusation of indeterminacy. Why is it so? We know that when this is how the stare decisis operate, or the doctrine of judicial precedent, that there is a matter before the court, and someone will say that this matter is actually governed by this case which was decided. So, for example, people will cite the case of Ejuechum versus Attorney General, or people will cite the case of, let's name it, contracts, NTAC versus what? Entry, and so on. But as whether a particular precedent, which has been mentioned before the court, will be actually followed in a particular case, is very much dependent upon the court making a determination as to whether the material facts of that precedent are the same as the material facts of the case before the court now. And for that matter, it is not uncommon to get the court saying that, yes, the precedent you have proposed looks close to this case, but there is an aspect which is fundamentally distinct. There's an aspect in this case which was not in that case. And for that matter, we cannot say that what was decided in that case, the ratio dissidenda, is necessarily applicable here, because if the judge or the court which adjudicated that matter had this particular dimension, which we have in this case, in that case, probably that decision will have been different. And for that matter, we don't have to follow it. So here, you see how the judge has been able to reinterpret the past rulings from his own vantage perspective, as it were. So another postmodern critique of the law has to do with power and hegemony. So law is seen as being an instrument of dominant groups. We've talked about power relations already. And law is used to legitimize existing power hierarchies under the guise of neutrality. So to start with, for the postmodernists, as we have seen, there's nothing like neutrality in the law. The law is not neutral. The law is a reflection of the dominant group. So it's a reflection of the power relations. So for example, land law, we talk about, allodial titles and so on. Who are the allodial owners? Allodial owners, are they not the stools or the skins or the particular families? Or Hymen and Ejay, I hope you remember that case. Beyede and Mensa, Unano and Abude and all that. Hansen and Ankara. Now, if the allodia is owned by the particular stool, skin, or family, and if you have your landlord who says that the allodia is the highest interest, the highest quantum of interest which you can have in land in Ghana, is that not a way of legitimizing the view that it is a certain group of people who founded a certain community or who are supposed to be the overlords of a particular community? So that is the point the postmodernist is telling us. Again, language of rights or justice can exclude or undermine less privileged communities. And I think I use the Galamsey example as an illustration. Okay. Yes, let there be justice. You go and arrest people, they are prosecuted, found guilty, they're in prison. You think you are achieving justice. But as far as the people in this community is concerned, that is not justice to them. Because for them, the environment is destroyed. For them, the small businesses they were making from the illegal mining, their livelihood is also blown away. So not until they get all those things done, they will not have had justice. But from the point of view of the meta legal system, because the law says that they are not supposed to do this, if you're arrested and then if you're found guilty in prison, then justice is achieved. Again, postmodernists make the point that if you look at modern law, it often assumes a rational, autonomous individual. That is, a thinking individual who has the freedom to make choices that he or she wants. But postmodernists disagree, and they rather see identity as socially and discursively constructed. And for that matter, they challenge the ideas of absolute choice or responsibility. In other words, if you look at liberal democracy and other legal concepts, based upon liberal democratic thinking, we are often made to believe that the individual, for example, we take that the laissez-faire economy, when you're dealing with the freedom of contracts, pacta sunt servanda, isn't it? And all that. We are told that where you have a rational individual who has freely make a choice, then that should be respected. I mean, that is fine. But then the postmodernist is telling us that, wait a minute, this so-called individual that you say has made the free choice, the choice is not really free because that individual's identity, how the individual even think or how the individual sees himself, has been socially constructed. And the individual is not that neutral. And for that matter, whatever choices which the individual make should not be seen as a free choice, so as to say that the individual assumes responsibility over that. So let's keep that in mind. Again, postmodern scholars also attack what they call the hierarchies. So we have traditional elites, maybe like the courts, the legal academia. They claim expertise, but in the thinking of postmodern scholars, they think that expertise can actually block marginalized voices. That there are some voices that do not have the label of elitism. But whatever they are saying may also be very important. But because they don't have the badge of elitism, they are excluded, as it were. We want to illustrate postmodernism using feminist thinking. But I was going to do this because feminist jurisprudence will be taught. I intend to skip it so that when we are dealing with feminist jurisprudence, we will actually learn that. So we would like to draw the let me check the time. I have some few more things to discuss if we can continue. Okay, I think let's do some 10 minutes more. Then we have a little bit of time, so okay. So let's try and provide a brief case study illustrations of postmodernism. So we want to look at feminist postmodernism. You have heard of feminist thinkers, and they hold the view that the female perspective has been excluded for a long time from almost everything we call knowledge, almost everything we call governance and law. And it is the male perspective which has actually been the dominant view. And that has shaped everything we have with respect to knowledge, with respect to law, with respect to governance and everything. So they seek to make the point that it's time that we welcome and consciously incorporated the female perspective. So that is the basic understanding of feminism. So feminist theories have been influenced by postmodern scholars like Jacques Derrida, his deconstruction, and Michel Foucault's power knowledge framework. And they argue, that is, the feminists argue that laws on sexual assault or harassment often reflect patriarchal norms embedded in legal language. So if you take the various sexual offenses law, for example, feminist scholars influenced by these postmodernist thinkers will tell us that the law has actually reflected the male perspective and not. Let's take something like, for example, something like rape, okay? In our criminal law, rape, for example, is understood as the slightest penile penetration. And the emphasis is on the penile, like the use of the penis, uh, of the female, the vagina. So that is what constitutes like the rape, isn't it? But of course, one would say that it is because of how the male perspective of sexuality or sexual experience plays out. That is why that is the law. But for the female, an argument will be made that it's not only about the penile penetration, which is the summit of the sexual experience. So if that is so, why is the law on rape framed that way? Isn't this certainly because it is a male-dominated, viewpoint which influences? So that those are some of the things that they try to explain. So one leading feminist scholar, Catherine McKinnon in Canada, in his important work toward a feminist theory of the state, made the point how legal definitions of crime and liability can marginalize women's experience. Right. So, for example, by focusing on physical violence or specific intent, while overlooking broader context of coercion, power imbalances, and cultural stereotypes about victims' behavior. And I think the example that I gave you with the rape also provide you some practical illustration. So postmodernist readings bring out how traditional courtroom discourse may trivialize or invalidate survivors' narratives, and for that matter, produce outcomes that are biased toward male-centric interpretations of consent and what and harm. And I think that there may be some points regarding some of these feminist views, except that we also have what we call the extreme feminist type, which really go very far, and they also take matters overboard. So that is the other thing. So going by this line of feminist thinking, it will call for transforming the law in a way which will involve more than merely amending it. It requires questioning the very language in which the law is crafted, the assumptions, the epistemic frameworks that have historically shaped notions of proof, credibility, and justice. So I give you another example. When it comes to evidence, for example, where you call your spouse as a witness, in terms of weight to be given to the evidence, is really, really, really low or nothing, as it were. Why is it so? Is it based upon the thinking that, assuming if the man is the one calling the wife a witness, is it based upon the thinking that the wife is not capable of independently speaking the truth and will always be biased by the feelings that loyalty or feelings that he has towards like the spouse, as it were? Is that the case? Well, let's look at another illustration of postmodernist thinking. That's a critical race theory. The critical race theory is a whole bunch of approaches that have been put together, but they essentially draw on postmodernist insight to reveal how supposedly colorblind legal doctrines perpetuate structural racisms. Yeah, so of course, once you see the race, you know scholars behind that. Those scholars who hold the view that the law, the legal system, society have been constructed as if it is only one race which exists in humanity. But we have different races. And if we have different races, why is it that the law, the legal system, various societies, the international system have been designed as if it is only the white race that live in the various countries? So that is the accusation of the color blindness of legal doctrines, which critical race scholars hold the view actually perpetuate structural racism. So if you take scholars like Richard Delgado and James Stefan, for example, they did a work called the critical race theory, an introduction. And they will bring out how laws or legal precedents which claim neutrality can actually reify racial categories and maintain existing hierarchies. In other words, how law can actually be presented in a way which seems to legitimize or let racism appear to be normal, appear to be okay. For example, anti-discrimination statutes that prohibit only explicit racial bias might fail to address subtler forms of systemic inequality, maybe such as disparate policing or inequitable funding of schools. Of course, in our part of the world, we don't have the problem of racism because we are one race, but we have our own version, tribalism, our own version of tribalism, ethnocentrism. But as to whether tribalism and ethnocentrism have actually been elevated to the pedestal of racism, which provided the impetus for scholars of critical race theory to actually do the kind of thinking that they did, is something that we can continue to debate on. So postmodern perspective underline how legal texts, judicial opinions, and legislative debates can be understood as narratives shaped by and sustaining dominant racial ideologies. Of course, we may agree or disagree with some of the claims of critical race scholars. I mean, those who are very worried by racism and also colonialism, but as to whether you agree or not, I mean, that one, you have no obligation. For that matter, critical race theory scholars call for a more contextualized, historically informed approach to law that exposes hidden assumptions about race and challenges the status quo of white privilege. Now let's look at our third case study, the LGBTQ rights, or what they call the sexual minorities. So when it comes to postmodernism, it's something which is actually used by scholars who advocate for LGBTQ plus rights. So postmodern's legal analysis of marriage, gender, and family law emphasize that these institutions are social constructs that have been shaped by history, culture, and political power. So, for example, they say that, well, marriage is a matter which history and culture has actually shaped it, and not because it is objectively there. And again, family law, these are all matters of reflections of history, culture, and political power, and also gender. But for gender, I think the UK Supreme Court has actually come out with a decision, which I'm sure you have seen. If you haven't seen it, or if you have, just put it on the platform, in which the UK Supreme Court makes the point that gender is determined at birth. It's a question of biology. You are born a male or you are born a female. So you don't have any nonsense like I'm a male and I feel that I'm in a female body. So I'm going to do a surgical operation, get my genitalia removed, reconfigured from penis to vagina, and then I get some hormones and I start, behaving like a woman. And then when you're asked, "Sir, madam, what is your gender?" And I say, "I am he, she," or "I am now, she." When at the time that I was born, when I came out of my mother's womb, I was immediately declared a boy because of how I came out. And subsequently to have undergone certain things, and I want to call myself a female. I mean, that was a confusion. And then the UK Supreme Court has said that, well, as to when it comes to gender is determined at the time of birth. So please, let's read that decision. So rather than viewing the family as a natural and universally fixed concept, postmodern and queer theories, the queer theories are those scholars who advocate for the rise of LGBTQ. The queer theories argue that legal definitions of marriage or parenthood reflect dominant norms about gender roles and heteronormativity. So that they are trying to say that there's nothing objectively neutral by saying that it is a male and female who should be the parents of a child, that marriage should be between the opposite sexes and not the same sex. So they are trying to say that those things are not objectively derived, but they are reflection of history, culture, and political power. Well, I have to let you know, but I don't agree with their thinking, but their thinking is there. So by questioning the language and categories, underpinning traditional family law, advocates for LGBTQ plus rights call for inclusive family works that recognize diverse live realities, such as same-sex parenting, gender non-conforming relationships, or polyamorous partnership. I know it's very, that's another interesting view, but as whether it's acceptable to you or to me, I mean, that is something else. That is not what we actually concern ourselves with, but just for you to be aware that those things are there. And their perspective actually challenged the assumption that one model of family life is correct or normal. And for that matter, they seek to enable broader legal recognition of people's varied experiences. So we're trying to say that, well, if you remember your conflict of laws, Lord Penzas, in the case of Hyde and Hyde, made the point that marriage is a union between a man and a woman, isn't it? To the exclusion of all others. Lord Penzas made that definition. Now they will disagree and rather say that that is not all that there is, and it is possible for people to be married to trees, to animals, or to whoever. Well, the debate is there. You can continue to have those debates at your level. So, what are the implications of postmodernism for legal practice? Well, they would definitely prefer interpretation over discovery. You know, in the law school, we are told that to become a lawyer, the things you need, you have to know where to find the law, how to find the law, and then how to apply the law, isn't it? So that is a discovery. But postmodernists will tell us that no, it's about interpretation. So lawyers and judges must acknowledge the interpretive element of legal work and recognize personal bias and context. Of course, that also reflects aspect of the American realism or Scandinavian realism. We've also noted already how they emphasize localized justice rather than universal justice. So postmodern theory suggests case-specific adjudication. If you have a question, just put it in the chat. I will look at it and then answer it. Postmodern theory suggests case-specific adjudication attuned to cultural and situational variables. They also incorporate perspectives which are often ignored by formal law. And that way, they seek to ensure a broader range of experiences are considered or are taken account of. Of course, they also have skepticism of neutrality. Postmodern scholars encourage practitioners to question how laws and institutions might influence certain interests under the veil of neutrality. But I must say that when it comes to actual law practice, probably when it comes to interpretation, okay, rather interpretation of evidence, we're doing the evaluation, assessment of evidence, and in the very limited situations of novelty, maybe where the court will have to be assisted to actually interpret the law or legal doctrine in a completely new way, which has never been done before. That you may fall on some of these ideas as a way of persuasion. Of course, postmodernism has also received criticism. One is the charge of relativism. Postmodernism actually encouraged relativism, and critics claim that postmodernism's openness to multiple truths undermines stable legal norms. Just imagine, we often talk about certainty and predictability, isn't it? That there should be certainty and predictability in the law. And of course, the basis of stare decisis, the basis of stare decisis is actually the need for certainty and predictability. So therefore, if you follow the teaching of postmodernists to its elastic limits, you may end up having no stable legal norms because they say that everything is relative. So if everything is relative, there's no certainty, and that is problematic. Another criticism against postmodernism is that excessive deconstruction can lead to paralysis, where no common ground can be found to uphold order. So if you keep questioning everything and saying that there is no neutrality. That is fine, but then you end up not having any settled position. So that is the problem of the paralysis. And again, the point is made that even if postmodern scholars choose to rely on moral or political stance like social justice, that would suggest some commitment to universal values. Yes, you're saying there's no need for universal values, but if you are talking about social justice, for example, localized justice for marginalized or for certain groups, that in itself is acknowledgement of some universal values. Now, critics of postmodernism argue that postmodernism is better suited to academic critique than to day-to-day governance, which demands workable solution and consistent rules. So this, I mean, it's interesting exercise in the world of, academy, in the world of pursuit of knowledge. But then when it comes to day-to-day solution, when the courts are working, trying to find solutions to problems, when lawmakers, law enforcers, policymakers are working, trying to generate workable solutions, the teachings of postmodernism may not provide ready-made support or answers. So it should be confined to the classroom like we are doing now. But if you want to have a bit of a relaxed approach, can we integrate postmodern insights? So can we have a constructive approach? In other words, we are not going to follow postmodernism hook, line, and sinker. But then we see some good things, some attractions in postmodernism. So can we borrow those ones? So there's a need for balanced skepticism. So in that case, we need to recognize the need for stable rules, but remain aware of how these rules embed certain viewpoints. Yes, we have to recognize existence of rules, but at the same time, we must also appreciate that the rules that we are recognizing are not neutral, as it were. In terms of approach to, we need to embrace methodological pluralism. So in this case, Rorty will say that we need to combine postmodern critique with pragmatism or other theories, maintain flexibility and functionality. In other words, we can blend other approaches with postmodernism. Of course, there's also the need to encourage open discourse, which engages marginalized voices in legislative or judicial decision making. So now let's take our current constitutional review committee, which is working, trying to collate views regarding how we should amend our constitution. And the way they are going about it enable almost everyone who cares to make a contribution towards what our reformed constitution should look like. And of course, when it comes to judicial decision making too, we have the use of the jury, we have assessors, we have referees that may be appointed. So all those things ensure that marginalized voices are taken care of in even judicial decision making. So how does postmodernism relates to other jurisprudential schools that we have seen? If we take the natural law, for example, postmodernism questions any claim to universal morality or an overarching rational order in law. So this will tell you that postmodernism has actually part ways with natural law, because natural law is about universal morality or overarching rational order. But postmodernism actually questions that there's nothing like that. What about legal positivism? Well, positivism, as we know, views law as systematically created by recognized authorities. The law as posited, the law as put there by the one with authority to lay down laws. But postmodernists focus on how language, discourse, and power shape laws, creation, and interpretation. So over here too, we see similarities and also contrasts. What about critical legal studies? We have seen that it's similar to postmodernism in exposing the law's political nature. But critical legal studies often maintains a more unified political critique, whereas postmodernism can be skeptical of any single framework. So, yes, we see some similarity between critical legal studies and the postmodernist thinking. The only difference is that uh, critical legal studies has, if you like, a unified or consistent political critique, but postmodernism uh, actually does not have any particular single framework for critiquing, and is even suspicious of any single framework. It's rather use the multiple perspectives. Of course, we've seen feminist jurisprudence, and we've noted how feminist theory can overlap with postmodern critiques of patriarchy and language. Although some feminists retain normative goals like gender equality, which postmodernism may view as another universal claim. So, postmodernism is against universal claims, but if we take feminists, we have some versions of feminism which actually seek to have what they call like the gender equality. As whether that is feasible is another thing altogether. Good. So our basic takeaway is that postmodernism is doubtful as far as any single universal truth in law is concerned, and rather emphasize how language, power, and discourse shape norms, including law. So we're seeing thinkers like Michel Foucault, Derrida, Lyotard, and how they reveal how the search for objective legal meaning often overlooks embedded power relations. Of course, notwithstanding the practical challenges we have identified as far as postmodernism is concerned, it is still possible to derive some benefit from postmodernism, especially as it sharpens our awareness of biases, hidden assumptions, and social construct behind laws. So we'll take the questions at this stage. Let's see. yeah, we have so many scholars behind the LGBT. So it's a whole area. If you have interest, we forward the articles. So if you look at um, the reading list we have, it's a whole area. People have written on it, but it's not something I'm interested in, so I don't spend a lot of time on it. Let me release the mic.